All right. Good afternoon. This is Eric Hauge, Executive Director of Homeline, and you're joining us, both myself and Homeline's Managing Attorney Mike Draw, on Thursday, June 18th at 1:30 for our weekly webinar related to COVID-19 pandemic rental legal issues. This one designed for an audience of landlords and property managers. Again, a reminder what Homeline is. We're a statewide nonprofit organization. The main program is a free legal hotline over the phone or via email in 4 languages: English, Spanish, Somali, and Hmong. And our hotline answers legal questions that renters have about their rental housing just in the state of Minnesota. And we have been hosting these webinars since about mid-April, and we'll continue to do so for the time being. And again, Mike's going to do a quick run through of some of the basic information that we've covered most weeks. And then we did get some questions submitted in advance. And so we'll take those first, and are happy to take anybody's questions over the Q&A system or via chat on the Zoom system. So with that, I'm going to pass it over to Mike.
Thanks, Eric. And Eric is right. We will have time for questions being submitted during the presentation today. That's not always the case. As he mentioned, we have 3 or 4 questions that were submitted in advance, and we'll get to those. But we'll spend 15, 20 minutes at the beginning of the session talking about sort of the state of things today as respect to COVID-19 landlord-tenant law in Minnesota and where things sit. So Eric, if you could take us to that first slide, thank you. So this remains, the eviction moratorium remains sort of the big shadow over landlord-tenant law in Minnesota right now. This dominates the landscape when it comes to that arena. And quick update on what we have, where we are with the eviction moratorium in the state. So again, this is a state rule. It's not one county, it's not one city, but it's just in Minnesota. But the governor issued an executive order in mid-March that effectively stopped all evictions from going forward. There are a few exceptions to that, but they're minimal. The 2 exceptions to the eviction moratorium are if the tenant has seriously endangered others on the premises. So that was tweaked a couple weeks ago. The governor amended the executive order, and it used to say that the tenant could be evicted for seriously endangering other tenants, but it has been expanded to include others. So the word tenant is no longer there, or residence is no longer there. And I guess that includes now the new version of the rule that would mean that if a tenant is endangering the landlord or the landlord's employees, delivery people, somebody delivering the mail, a guest of a tenant, any of those would be fair game for a landlord being able to file an eviction under the exception to the eviction moratorium. The other notable exception that's been there since the beginning is tied to a specific state law, Minnesota Chapter 504B.171. Those of you that are looking up a law want to know what the law says about a landlord-tenant situation in Minnesota. The starting point for almost everything is that chapter 504B. Not 504, not 504A, but 504B. You can actually find all 3 of those, but 504B is the current one. It's the only one that matters. Point 171 refers to some specific behavior. This predates COVID-19, by the way. Specific behavior that a tenant can't engage in, or else they can be evicted for in their rental unit. Possession of illegal drugs. There's a list of drugs that count as illegal. Pretty much everything you'd guess would be there is there. Illegal guns, sawed-off shotguns, automatic weapons. Again, there's a list of illegal guns. Stolen property, that's what we mean by contraband. Prostitution. So those are the exceptions. Pretty much every other eviction the landlord might think about filing right now, and this has been true since mid-March, they simply can't file it. So non-payment of rent, which is the reason for well over 90% of evictions in Minnesota, landlord can't file an eviction for non-payment of rent. An unauthorized occupant, a boyfriend or a girlfriend living there, a breach of the lease, like not having a pet when the tenant's not supposed to have a pet, or smoking in a non-smoking building. a landlord simply can't file an eviction against a tenant during this time. Also, the eviction moratorium stops a landlord from terminating the lease during the pendency of the emergency. So landlords and tenants end leases all the time. About once every 2 or 3 years on average, tenants turn over. So a tenant has been able to, since the beginning of the peacetime emergency declaration, give their own notice. Landlord, I want to be done with my lease. It ends at the end of May, and so I'm giving you my notice. Or if it's month to month, the tenant gives a notice of a month in writing, and that's probably going to be sufficient. The old rule, the pre-COVID-19 rule, was that if a landlord wanted to non-renew someone or give them a notice to vacate or a notice to quit, all they'd have to do is give the same amount of notice that the tenant would probably need to give. So 1 month if it's month to month, or full rental period, I should say, or whatever the lease might require. But during the COVID emergency and under the eviction moratorium, a landlord is not allowed to terminate a residential lease during that time. So if a landlord gave a notice of non-renewal for the end of May, clearly they can't enforce that, because the traditional remedy for a landlord, if a tenant didn't leave on May 31, would be to go file an eviction on June 1 for something called holding over. That's not available to a landlord right now. The larger question, which has been sort of a question we've had, and I think landlords have had as well, since the declaration of the peacetime emergency, is can a landlord give a notice today for some time past the stated current end of the peacetime emergency declaration. So the current emergency declaration that we have ends officially in mid-July. So can a landlord give a notice today, which is June 18th, for the end of July if they're a month-to-month tenant and the rent is due on the 1st? Traditional pre-COVID-19 answer would be, yeah, probably so. Might have to look at the lease, but yeah, probably so. But during COVID-19, the question is that the landlord terminating the lease during the pendency of the emergency? Because they're actually giving the termination today while the peacetime emergency declaration is still in place. And our view has always been, yes, we think that that is violating the governor's order. The Attorney General's office is the entity that's supposed to enforce this rule, the entire eviction moratorium, and they've been very busy since all of this started happening in mid-March. And they have been telling landlords in letters and over the phone, hey, you can't give a notice ending the lease even in advance past the time of the stated declaration of the peacetime emergency end date. That's violating this statute. What's the penalty? Well, it's a misdemeanor. It's up to $1,000 and up to 90 days imprisonment. One thing that was very clear from the governor's order from the very beginning in mid-March is that rent is still due. There's no rent cancellation. There's no rent forgiveness. The rent is still due under the governor's order. And again, this is the state rule that we're talking about. We'll talk about the federal rule in a second, but for now, let's talk about how long this might go on for, the Minnesota eviction moratorium. So, and this is always the biggest question that we get. We give these speeches twice a week. On Wednesday, we talk to tenants and social workers and people that work with tenants. On Thursdays, we talk to landlords, property managers, people like that. And this is always the question that we get a lot of, especially from the landlord side, is, well, wait, when can I file an eviction? I haven't been paid since March was the last time I got paid rent, and when can I file the eviction? So the answer has shifted, obviously, since this all began. The current answer to the question is, under the state law, a landlord certainly can't file an eviction for non-payment of rent until July 13th. So next month, almost a full month away at this point. The order was announced on last Friday officially on June 12th, at which point a special session was immediately called. That's how this works. This is a very confusing set of things to try to keep track of, and it's one of the reasons we actually give these speeches, is because it's hard to keep track. When does the eviction moratorium end? When do the shelter-in-place orders change around? Because we've all seen this stuff online, in the newspaper, social media, where there's dials where the governor is talking about opening the state up a little bit more, whether a barber can open up, whether a bowling alley can open up, whether a theater can open up to show movies, whether a restaurant can open up. Can they only be open up outside, or can they be open up inside but only half full? All these rules that have been around the shelter-in-place order don't mean anything for the eviction ban. The eviction ban is tied to the peacetime emergency declaration. So the governor issued that, again, in mid-March. The peacetime emergency declaration doesn't just affect evictions. It's not the only thing that it deals with. There are a host of other things that it relates to. But for a landlord-tenant perspective, this is the key thing. The eviction ban, the eviction moratorium, another executive order from the governor, is tied in time to the peacetime emergency declaration remaining. So that's the key thing we're looking for. All the shelter-in-place stuff that you might see, will a beach open? Can daycare open? Will there be camps for kids in the summer? Are they openable? None of those matter. The shelter-in-place, stay-at-home type orders, when it comes to finding out, does the eviction moratorium still go on? It's all about the peacetime emergency declaration. And that can be extended by the governor, as near as we can tell by looking at the statute, every month, perpetually, in theory. It looks like that could happen. The state legislature could also pass a rule extending it as long as they wish to extend it. I think that's unlikely given the makeup of the state legislature, but it's theoretically possible. Probably the more important question from a landlord's perspective is, okay, what could end the peacetime emergency declaration? So in my view, there's only really, I guess there's three ways that this could end. One is the governor could end it. The governor could just decide, you know what, it's my executive order. I'm going to withdraw it or take it back or end it, issue a new executive order ending the first executive order. And that's how amendments have worked, by the way, with the governor just announcing, hey, I'm going to change this thing slightly, so here's what it's going to be. So the governor could end the peacetime emergency declaration. I think that's pretty clear. The state legislature also has the power to end the peacetime emergency declaration. And one half of the legislature tried to do that on Friday. So Friday, the special session began. The governor, by extending the peacetime emergency during a time when the legislature was not in session, that triggers an automatic rule that says a special session has to happen. How special sessions work generally is the governor can call them at any time, or it gets triggered automatically here. And once the special session is called, the legislature alone gets to decide when they're done with their special session. So they could call an end to it today, or they could wait forever, I guess, to end their special session. But on Friday, last week, when the declaration of the peacetime emergency extension was given by the governor officially, the Senate, which is controlled by Republicans, they hold the majority number of seats in the Senate, voted to end the peacetime emergency declaration. It's a simple majority. You don't need to have 2/3 or some sort of veto-proof number. A simple majority is enough. The House, which is controlled by Democrats, voted against ending the peacetime emergency declaration pretty substantially too. So it wasn't really a very close vote in the House. And both chambers have to vote to end the peacetime emergency declaration. Only other way I can foresee the peacetime emergency extensions ending is if there was some sort of court challenge from somebody. And again, it might not even be a landlord. It might be somebody else who doesn't like the peacetime emergency declaration. If that is taken up to the state Supreme Court and the state Supreme Court says somehow the governor has overextended their power under the statute. I haven't even heard of a case being filed like that or threatened to be filed, but it's happened in some other states. And I'm guessing it depends a lot on the original statutory language that created the peacetime emergency in each state is going to be a huge factor in figuring out whether or not a governor has this unilateral power. I mean, nobody's questioning whether it's unilateral or not. Of course it's unilateral. That's how it's designed. But it was designed as a statute. So it was enacted by the Senate and House and signed by the governor into law whenever that happened. I don't even know when that statute was invented. But so it was a tri-branch, or at least a double branch agreed upon approach to dealing with emergencies in a peacetime setting. And so that's what we have right now. And as near as we know, July 13th is when it officially ends. Can the governor extend it? Maybe. Will the governor extend it? We don't know. We're asked about this a lot. We know some people that work in the governor's office, but I don't think that those people know what the governor will do. In our view, the governor has been waiting until the last minute every time to decide. based on the latest information, a number of people that are reported to have contracted COVID-19, number of hospitalizations, number of fatalities, trying to use the most up-to-date information. So I think that the governor might have in mind how long that they want the peacetime emergency to go on, but I'm guessing they're going to look at the numbers on July 12th and say, this is what we need to do based on the information that we have in front of us right now. And so that will be probably the determining factor. If the legislature ends their session before that time, before July 13th, as I understand the rules, the governor would once again be immediately triggering a special session by declaring another peacetime emergency extension. This stuff gets a little bit in the weeds, and I apologize for that, but if you want to know sort of how does the governor have this power, it's a state law that gives him this power to do this, not the governor just declaring this out of thin air. This existed long before Governor Walz was in the office. And this is the impact that it has on the landlord-tenant arena, is the eviction moratorium. But the state question, what's the rule in Minnesota, isn't the only question. The federal law also plays a role as well. Now, this is rare in landlord-tenant world. It's pretty uncommon that there's a federal law that has much of an impact. There's some discrimination rules, but other than that, we don't really look at federal laws when trying to figure out what a private market rental rule is in Minnesota or in any other state, frankly. It's a state-to-state thing. But the CARES Act was federal legislation that happened in March of this year, reacting to COVID-19, obviously. And it did a lot of things. I've never read the whole thing. I think it's 1,000 pages at least. Maybe I'm wrong, but it's massive. But one of the main things that it does for our line of work, once again, is it bans evictions from being filed through a certain date, July 25th. At that point, though, a landlord has to give a notice to the tenant saying, hey, you haven't paid. So 30 days from now, I can file an eviction. So if the CARES Act is in play with a landlord in Minnesota, they can't file an eviction for non-payment of rent until late August of this year. Now, this is only for non-payment of rent. So the Minnesota eviction moratorium that I mentioned earlier covers non-payment of rent. It covers any breach of the lease except for seriously endangering others on the property, or the drugs, guns, prostitution, stolen property rule that we talked about already. So those are the limits that a landlord has to consider when they're trying to decide, hey, wait, when can I file an eviction? There's two hurdles that I think a landlord has to get past, at least under the time frame that we're in right now, before a landlord says, yes, I'm going to file an eviction. Number one, is the state moratorium lifted yet? If it's not, then that probably ends the question, unless the tenant's doing something more or less illegal. Or if Governor Walz decides on July 13th to end the peacetime emergency declaration and the eviction moratorium goes away with it, can a landlord go file an eviction at that point? Well, maybe, unless the CARES Act is in play in their situation. And let's talk about when it matters. If you could, there you go. Thanks, Eric. So the CARES Act doesn't cover every tenant in the state. It covers ones specifically sort of enumerated in the federal legislation. So the official way to understand what's covered by the CARES Act is to start with anything that is covered by VAWA, the Violence Against Women Act, is a really broad umbrella. And so it includes things like public housing, somebody that has a Section 8 voucher, project-based housing, low-income tax credit properties, wherever there's a federal subsidized presence at all, there's going to be a CARES Act coverage, almost certainly. But the harder question is, what about a duplex in Minneapolis? I mean, is that covered by the CARES Act? And the short answer is maybe. It depends on the mortgage that the landlord has. So many mortgages throughout the United States are federally backed. Fannie Mae, Freddie Mac, we've all heard of those things. And if that's the case, then the CARES Act applies. Again, for just non-payment of rent cases, not for a breach of the lease, but for non-payment of rent cases. And so how do we know if a landlord has a federally backed mortgage? Well, honestly, a tenant probably can't figure that out, certainly can't figure it out quickly enough, even through discovery. Evictions happen really quickly. They're 20 to 30-day processes, and the court time from the day the landlord files the court case to the day they're guaranteed court normally is 14 days. The legislature passed a rule this during COVID-19 saying, hey, those deadlines can be relaxed, but we've heard courts are going to try to meet them anyway. We'll see once the floodgates open on the evictions, but because it's going to be a lot of evictions. But anyhow, the landlord is probably the only party in the world that can know that quickly enough. And so what many other states where evictions have been restarted since the COVID-19 restrictions were put in place, the courts are requiring landlords to swear under oath, so penalty of perjury, that they do not have a property that's covered by the CARES Act. And so the penalty would be, I guess, criminal charges if the landlord lies about that. The landlord's got to do a little digging, and the landlord can figure this out. They can go to wherever they got their mortgage, down the street to the bank, and say, hey, where did, is my mortgage federally protected or not? And the bank should be able to tell them. Now, the question that we get asked a fair amount is, hey, what percentage of properties are covered? And we don't know. Nobody's ever really tried to put pen to paper and figure this out because it's never come up before now because the CARES Act didn't exist before March. So 20, 30, 50% maybe of Minnesota rentals might be covered by this. We're really not sure. But it is a substantial number. I mean, especially when you count all the known federally assisted housing programs. But then you start looking at, all right, how big a footprint does Fannie Mae and Freddie Mac have? And it is pretty substantial. So it will have a big impact. My hunch is that, although we haven't gotten an official word from the state Supreme Court on that they'll probably have similar requirements that the landlord will have to state that they are not covered by the CARES Act. Although, to be honest, looking at the calendar, we're starting to get to the point where it's going to matter less and less because the CARES Act only provides protection to July 25th, at which point the landlord has to give a 30-day notice. So then we're talking August 25th. Governor Walz's latest extension of the peacetime emergency declaration is to July 13th. So it's closing in on those CARES Act deadlines that we've been talking about since we started doing this, which looked a lot more distant when we started in mid-April, but now they're, like I said, they're getting closer. So we talked briefly about whether Governor Walz was going to extend the peacetime emergency declaration, which is all speculation. I think it's easier to guess about the CARES Act protection. Will that be extended? My strong guess is that it will not be extended. I don't think we've seen any realistic moves afoot at the federal level to extend much of what the CARES Act is or a specific part of this. Now, that doesn't mean that it can't happen. It certainly could. As that deadline approaches and people start to realize what's about to happen, they might decide at the federal level, wait a second, we can't open it up like this that quickly. But at present, if I had to bet, I would say that I think that this is going to expire when it's set to expire, but you never know. Okay. Yeah, go ahead, Eric.
Right. So yeah, we do have some questions that were submitted in advance. I'm going to bring those up.
And please do submit other questions. Quick preview, by the way, of next week. We're going to be talking about a new topic. I'm giving another speech for a different, a judge asked us to give a speech on something else. And so I'm going to be talking about trying to guess the number of evictions that are going to be filed. It is a guess, but it's going to be an educated guess, an informed guess, and put together the numbers already, and they're pretty startling. But that's going to be something we're going to talk about next week, is trying to figure out exactly how many evictions might be filed when the eviction floodgates open up here in Minnesota. But as Eric mentioned, we had 3 or 4 questions that were submitted in advance, and please feel free to submit your COVID-19 specific questions, or if you just have a landlord-tenant legal question that you want to submit, you got a lawyer in front of you, and there's no charge, feel free to try and we'll try to answer it if we can.
Right, yeah, so the first question submitted in advance. Can you increase rent if a tenant is on a month-to-month lease? I don't want to tie myself down to a longer-term lease, but do want to raise rent.
Right, right. Question that we get fairly regularly here. Don't mind answering it at all. So obviously people want to know the answer to it, so we'll address it. So a lot of leases end in the summertime. In fact, most leases in Minnesota end in a 5-month window. At least term leases. What I mean by term lease is 1-year term, 2-year term, 3-year terms, most common being 1-year terms, of course. Some college areas, leases are sort of 9-month leases, but most colleges, landlords prefer 12-month leases, even though the student might only be there for 9 months. So most leases end kind of now. This is the period where leases end. In fact, this is the time of the year that our tenant hotline is traditionally the busiest because, well, when people move in and move out, there might be issues that come up between the landlord and the tenant. Security deposit questions are almost always sort of summer loaded for us. But anyhow, this is when landlords are thinking, okay, I've looked at my market analysis. I think I can charge this for rent. And so I'd like to raise the rent going forward. Can I do that under the governor's order? So there's a couple orders that you have to consider when trying to answer this question. The first one is there's an order from the governor that stops price gouging. Okay, so is it price gouging to raise the rent in our rental unit? So there's two ways it could be price gouging under the governor's order, and I'm guessing that Eric will post that under the chat. He's been posting a lot of other things here. Two ways it could be violating the price gouging rule. Number one, there's a bright line price gouging limit, 20%. If it's over 20%, then it's considered price gouging. I think it would take some extraordinary explanation to justify it. On its face, it's probably price gouging and not allowed under the governor's order. By the way, the penalty for that, $10,000, violating the price gouging rule. The other way in which it can be a violation of the price gouging rule is a much more ambiguous rule that says that a provider of some sort of good or service can't charge an unreasonable amount compared to what it was like 30 days before the peacetime emergency declaration was made. And this is an essential service. Housing definitely falls under the rule, the price gouging rule. But let's assume for a second that it's not a massive rent increase. You got a landlord going from 1,000 to 1,050 or something like that, which is money, but it's not the kind of thing that would make people stop and stare at it and say, what is going on here? Could a landlord do that? So the next order we have to look at is, all right, is this violating the eviction moratorium? So the landlord's not filing a court case. They're not changing the locks. We get that. So that's not violated. But are they, here's the real question, are they terminating the tenancy at that point? Because when we think about a tenancy sort of on paper, what does a tenancy consist of on paper? What does a lease really have to be a binding contract? And there are sort of, in my mind, three pillars to a lease. The first is the length of time. So is it a one-year lease? Is it a month-to-month lease? How long is the contract for? The second one is how much is the rent? What's the cost? And the third one is, where is it? What's the address? Those three things. I guess the parties would be a fourth pillar if you wanted to have a four-pillar approach, who's involved in this. But the length of time, which spot are you promised, how much is the rent? Those are the three core principles of any contract. And if a landlord wants to raise the rent right now during COVID-19, are they terminating the original lease that was in place, would be the question. And we've seen some indication from the Attorney General's office that they view that as terminating the tenancy. So a rent increase right now during the COVID-19 pandemic peacetime emergency declaration, I think violates the moratorium on evictions where the landlord can't terminate a residency right now. I think it is ending the original contract and replacing it with a new one. Now, I think the good news for the landlord that submitted this question is it sounds like they think they're locked into another one-year lease. I don't think that's right. I think you simply go into a holdover situation where if your lease ended on May 31 and the tenant pays their normal same rent as May on June 1, it probably, almost every lease in Minnesota becomes by law a month-to-month contract going forward. Is probably what you're left with. It depends a little bit on the language of the lease that the landlord used originally. It might be a 2-month to 2-month lease effectively, but that's probably what is left, is it's a month-to-month lease. So the landlord isn't locked into a 1-year lease or more, right? I mean, some leases are 2-year leases or even 3-year leases. We've seen those types of leases in the last decade or so really proliferate. Tenants sometimes want them because they want their kids to get to the end of their school career, or there's a job that they know they're going to have for 2 years, but no longer. So they really want to lock in a 2-year lease. Landlords traditionally really like these leases too, because it, eliminates turnover in their mind. So a 2 or 3-year lease, one could see that ending in the summertime and a landlord concerned, wait a second, am I locked into the same amount for 2 more years or 3 more years, or the more common version, the 1 more year? I don't think that's what would happen. I don't think a new term lease gets created. I think it rolls over into a periodic lease. So the landlord's not stuck with that forever. So let's say, just thinking this through a little bit further, that the governor extends the moratorium on evictions through the end of September. Now we're past that window when landlords want to turn a place over, right? Because we're getting into the cold weather months. It's harder for a landlord to refill the place then. And the tenant wants to stick around too. Does the landlord at that point have to say, okay, I've always done 1-year leases with you, so I'm going to give you a 1-year lease that will end the end of next October or something when the weather's starting to get much worse? I don't think a landlord's forced into that. I think they can say, you know what, let's do a 9-month lease so it ends during the warm weather months. No law would be stopping a landlord from doing that, at least no current law. And so it's probably a solution that a lot of landlords would come up with. In fact, I give speeches to a lot of landlord groups all around the state, and many of them will tell me, you know what, I will only ever do a 1-year lease. It's always a 1-year lease, never anything less than that. And to me, I get the motivation why landlords want to do that, but it shouldn't be how long a landlord wants to start a lease. It should be when they want it to end. That's what a landlord should really think about. So let's say you have a tenant that walks out on a lease in November and somebody new moves in. Do you really want to do a 1-year lease with somebody so you just pass off that winter move out problem to the next year? No, you'd rather end that next lease either the next summer, or maybe it's going to be a 19-month lease or whatever. But there's no law that says that a landlord has to do 1-year leases. Even if that's all they've ever done before, they could say, well, circumstances changed. We want to make sure that we end all our leases in this 5-month window. And that's how most landlords end up doing it. But I wouldn't want to get stuck on the whole notion that you have to do 1-year leases if you're a landlord.
The next question, how can landlords handle occupancy violations and tenants not completing recertification paperwork with the housing authority for their units?
Okay. So yeah, obviously there's a subsidy of some type involved here, I think, as near as I can tell from that question. I'm not sure exactly which subsidy is involved, but there's a subsidy involved. I don't think that there's any way that a landlord could chase somebody out right now, even if they're refusing to recertify or they have an unauthorized occupant. There are other remedies that those landlords traditionally have in place, which is ultimately to threaten the subsidy, which is the real cost for many tenants that have a subsidy of some type, is that if they lose that subsidy, which might be the single most important financial asset in their life, that subsidy. And so the threat of losing the subsidy, I imagine, would stop most tenants from running the risk here. But if that's the case, you got somebody with an unauthorized occupant, I don't think that the landlord gets past either one of our two. Well, actually, the federal hurdle wouldn't matter at all for an unauthorized occupant. The CARES Act doesn't apply. But the state moratorium, our first hurdle that a landlord has to get over to be able to file an eviction, unless you're in a situation where the unauthorized occupant is endangering the safety of others on the premises, I don't think that a landlord can file an eviction at this time for that reason.
And I'm going to put in the chat. There are some links, some resources on HUD's website, both for landlords, tenants, and housing authorities as far as guidance around the CARES Act. And so you may get some information there or from the local housing authority. Next question. Tenant is in a congregate setting, leaves for days or weeks, coming back and exposing other tenants to COVID. Is this within the purview of serious endangerment?
I don't know. I don't know if it would be or not. I have not seen any cases filed for that purpose. And like every lawyer in the country, we try to give our advice based on how cases have played out before. Maybe there is a case or two that has happened where this has come up and I haven't seen it, but I don't know if that's going to work to get you to that point of seriously endangering the safety of others, because that's a pretty high standard, seriously endangering the safety of others. And unless you've got some sort of evidence that they are actually COVID-19 positive, they tested positive, and they are sort of coming back disregarding the danger that causes to others, it's more theoretical than anything else at this point, whether or not they're endangering the other people. I get that they are increasing the chance that they're endangering somebody else, but that's not the same as seriously endangering the safety of others. So if I had to bet, I'd probably bet against a landlord filing that case and winning here. I doubt that it would work, but a landlord might try it.
All right. Next question. I'm a landlord of a single-family home. I have a month-to-month lease with the tenant. House is also for sale, and part of the lease agreement states the tenant must allow a realtor to show the home with at least 24 hours notice. Tenant doesn't want to answer phone calls or return texts from landlord or the realtor. Also is not paid for 2 months. What recourse does this landlord have?
Yeah, it's a tough spot for a landlord, obviously. The truth is, I don't think there is much recourse that the landlord has in this situation, but I'll walk through it. And Eric is going to post our position paper that we produced on the privacy question. When can a landlord actually enter a rental unit right now? Which is a legitimate question that we've gotten increasingly since COVID-19 began. And I can tell you what the old advice was, which is a landlord has a right to come in to show a place for a reasonable business purpose, to re-rent to somebody else if the tenant's moving out, or to sell the place, certainly reasonable business purposes. But that statute, the state statute that I just was citing parts of, also has some phrasing where it talks about under the circumstances. So the circumstances are it's COVID-19, and especially if you have a tenant that is high risk, or they at least think they're high risk of contracting the disease, or if they contract the disease, they're impacted more than other people might be. They may not be willing to let a landlord come in right now. And so we're seeing this friction happen a lot. We actually keep track of why people contact us. We have about 75 different topics, and we note whenever somebody calls why they called. The concept of privacy, or when the landlord can enter, is normally in the top 10 somewhere, 9, 10, maybe 7 at the highest, for the reasons why people call us over a certain time period. But since COVID-19 began, it's number 2 or 3. We've just gotten a lot more questions about this because everybody's concerned about people being in their space. So my starting point with this is a landlord should work with a tenant. Can you set up a situation where a virtual tour is possible? Will a virtual tour suffice? And if it will not, then how do you do these other showings? And again, we've advised renters for decades that have dealt with landlords trying to do showings, especially for sales. It's a different world when it's the sale world versus showings for rentals. When it comes to the sale, the modern version of this is that, somebody wants to see a house, they want to see it in a couple hours. And so there's not a lot of warning that happens for the tenant. And there tend to be a lot of showings at right away, right? When a place gets listed, especially if it's sort of in that range where a first-time home buyer might be able to afford it, there might be, literally dozens of showings within a week period. And it's somewhat exhausting for the tenant. And despite the fact that a lease might say that the landlord has the right to show the place, that doesn't mean that it's the tenant's job to be a showing agent. It just doesn't. There's no law that says that they have to make it pristine and picked up after. If they have kids, it's really difficult to maintain a place in sort of open house condition, which is what the owner ideally wants, is that the tenant will do that they'll make sure that the place is really just amazingly kept. So it shows as well as possible. And I'm not kidding when I talk about 2 hours notice. This is what happens when landlords decide to sell a place. Is there's very frequently almost no notice. Somebody's going to try to race home from work to get the place cleaned up, or maybe their 12-year-old kid is home alone that afternoon. And the tenant is just not excited about the concept of having a showing, especially in the COVID-19 era. So what if the tenant refuses to allow the landlord to come in, or won't pick up the text or the phone? What does the landlord do? Well, the landlord's prime remedy is to go file an eviction, but can't really file an eviction right now, not for this. At least at the state level. The state moratorium would stop a landlord from filing an eviction. Now, I guess in theory, the landlord would have a claim against the tenant if somehow they could show that the tenant's unwillingness to cooperate here was, first of all, unjustified, which who knows? If this court case comes up someday where the landlord says, here's what the landlord will say, this is kind of the tenant's worst case scenario, is the landlord says, I would have been able to sell my house. You cost me a house sale, so I'm going to sue you for $200,000 because I couldn't sell my house because of you obstructing the sale. So they sue over that. And it's kind of an absurd concept for a suit, but okay, the landlord does that. The tenant says, Judge, I couldn't let people come in all the time. They would have been sharing the air with me, touching stuff. And, I'm high risk, and my mom is high risk who lives with me, or my kid's high risk and she's here. And so I just couldn't allow that. I wasn't going to let anybody in. That might be the end of the case. The judge might say, yeah, landlord, it says under the circumstances, and under the circumstances, there was a pandemic, so I'm not going to allow this to happen. All of that being said, landlords have, over time, occasionally decided to effectively hire tenants as showing agents. Now, I know how counterintuitive this would be for most landlords, but it's one thing for a landlord to say, you know what, we're coming in to do this showing. You got 2 hours. Sorry, it wasn't more notice than that, but we're coming in. Versus, hey, you know what, we have to do showing in 2 hours. I apologize. I didn't want to do them this quickly where you'd have such little notice, but I know what an inconvenience this is for you. And I know you got 2 kids that you're at home with, and you're probably thinking about having lunch because it was happening over the lunch hour. Here's a gift card to McDonald's, and so you can go through the drive-through and have a picnic in the park. And I apologize for the inconvenience. Now, landlords will frequently sort of recoil when given that approach, but it incentivizes the tenant to do a little bit more to make the place look decent. Now, I know some landlords that actually give a payment to the tenant for each showing, not a gift card, not a reduction in rent, just a flat out payment. So there you go. That is something that can sway a tenant to be more helpful in the showing process, to turn them into something of a partner versus an impediment, which I think is how it's sometimes seen. It can be really confrontational, this whole thing. Showings, I mean, any of you that are listening that have ever done a showing for a place that you're trying to sell, understand what you try to do to make it sellable. You try to make the place look as good as you can, and that's really a hard thing to maintain while living there. Again, like you say, especially if there's kids and you've got busy work schedules. So anyhow, those are some thoughts on that, but the position paper outlines pretty much our sort of more formally thought through legal considerations of that.
And there was sort of a related question that just came through in regards to the home for sale question. If that house were to sell, will the closing need to be delayed until after the governor's order is lifted?
No, I don't think the governor's order, again, I don't do real estate law, but I think the governor's order allows sales to go on. I'm pretty sure that's right, isn't it? Do you remember, Eric?
I would think so, but I think if the tenant doesn't want to leave, right? Like they don't.
Oh, you think that's what it's getting at? Yeah, I mean, if the tenant refuses to go, the landlord, the new owner, would still be bound to the lease, which is, if it's a month-to-month lease, they're still locked into that month-to-month lease. But I don't think that, I would bet quite a bit, and I don't have the order in front of me. And this would be in the shelter-in-place order is where you'd find it. But I'm almost certain that home sales are allowed to continue.
Oh yeah, they are for sure. I think this is it's just you'd have to try to negotiate something with the tenant.
Right, with the current tenant. If they're refusing to go, the new owner would have to figure out some way to negotiate with the tenant, maybe to be a cash for keys situation, or they wait till the moratorium is lifted and give the right amount of notice under the lease. Yeah.
All right, a couple more have come in. Mm-hmm. What can be a sufficient proof that the deposit and accounting of it has been mailed to the tenant within 3 weeks of move out?
Oh, okay. So not a very COVID-19 specific question, but that's okay. We open it up to others, and we still have about 15 minutes to go. We only have a few other questions that are here. So yeah, let's talk about deposits for a little bit. Sufficient proof that the deposit was mailed to the tenant. So, okay. The security deposit statute, which Eric will put up in the chat for you, really is where you want to start with analyzing any kind of security deposit questions in Minnesota. It requires that the tenant, in order to start the 3-week clock that Aziz mentioned in the question, 2 things have to happen. The tenancy is terminated, and the tenant provides a forwarding address or delivery instructions to the landlord saying, hey, here's where I want my deposit sent, more or less. Okay. So what is sufficient proof to show that the thing was mailed? Okay. In order to understand my answer, you have to sort of look around some other parts of Chapter 504B, which is what I mentioned earlier. And there's one that stands out in my mind for this question, which is something called the automatic renewal statute, 504B.145, if you want to follow along at home. 145 is where a landlord is trying to renew leases automatically or not. And please don't ask me questions about this because we only have 15 minutes left and I don't want to spend the time. What I'm bringing this up for is in the automatic renewal statute, it talks about ways that a landlord can give the tenant an automatic renewal notice. And there are only two ways mentioned. One is something called personal service, where one person literally hands it to another. The other is certified mail, which is what we all think it means, right? You have to actually sign for the mail from whoever's delivering the mail or else go pick it up at the post office. Certified mail is not required for the deposit to be returned. In fact, I think it says in the statute a postmark is sufficient as far as stamping the time, but there's no requirement of certified mail. The legislature could have required that. And in fact, we know they could have required it because they required it elsewhere. So they know how to insert those words into one of these statutes if they want to, but it's not there. So simply mailing it generally is going to be considered sufficient proof that the landlord has sent the deposit letter. Now, mail gets lost, obviously. That does happen. And then the landlord's going to be in a bit of a tough spot, but they could swear under oath, hey, I put it in the mail on this date. And so the tenant, should have gotten it by, 2 or 3 days later. The key question, by the way, when it comes to the deposit being mailed is the day that it was mailed. So it doesn't really matter what date a landlord puts on a security deposit disposition letter, even if they write down, June 20th, but they don't actually put it in the mailbox until June 25th. So what I always tell tenants that are, and we're actually getting to this time of the month, it's the 18th right now. And so we're going to get the calls from tenants saying, where's my deposit? Even though the 21 days aren't up, because they want that money back. They need it to, get whatever they need for their new place. Anyhow, we get these questions, and what we are almost always telling tenants is, wait until the 25th or the 26th. You look at the calendar, you figure out where weekends are, when mail's going to happen. And if you get something from the landlord, keep the envelope. The postmark is the thing that matters. That's what really counts. So if I'm a landlord and I'm really concerned about this, I'm going to make sure that things are turned in by the 21st day at the very latest, and I'm not going to mail it at midnight on the 21st day or 11:59. Technically, that would be okay, but why risk it? And so I try to get it in so it can be postmarked that day, which would eliminate pretty much any question that a court or certainly a tenant trying to decide whether to go to court would have. By the way, the penalty for a landlord missing the 21-day rule is really substantial. It's a doubling of the deposit plus interest. So again, having done this a long time, the most sophisticated landlords never miss the 21-day deadline. The big giant landlords with 10,000 units, I don't know what happens on the 21st day if they have big bells and alarms and whistles that go off, but they don't miss the 21-day deadline because it's just such an expensive penalty against a landlord if they do. The landlords that miss it are the ones that aren't professional landlords. This isn't their only line of work probably. And they're the ones that might miss that 21-day deadline. And like I said, the penalty is so massive. One other thing that I will mention about this, it's not like I've seen this increasingly, but it pops up, I don't know, half a dozen times a year at least, where a landlord will send a letter during the 21-day window saying, you know what, I'm working on it. I'm working on your deposit. I haven't figured it all out yet, and I'll let you know when I do. But since I've sent you this letter within 21 days, I'm covered, which isn't what the statute wants the landlord to do. They want you to figure this out in 21 days. You get that amount of time, not much more. Some states it's 2 weeks. Some states it's 30 days. 21 is sort of in the middle of those, but that's all the time you get to figure out exactly what the damages are. You don't get an extension on figuring this out by sending a letter on the 20th day. Again, I've actually seen 1 or 2 really large landlords try that, and it's just mystifying that they think that that would suffice under the statute, because if they're right, a landlord never has to send the deposit back, right? Just send I'm working on it on day 20 and then never send anything more. There's no second deadline built into the statute. It's just the one deadline to meet. And having the postmark on the envelope is something that I would strive for if I'm a landlord.
Right. One that came in here.
Mhm.
When the CARES Act ends and we have tenants that have not paid during the pandemic, the lease states that we can give a 14-day eviction notice for non-payment. Is the CARES Act stating that landlords have to do 30-day notices?
Wow, there is a lot built into that question. So keep it on the board for a second, Eric, so I can make sure I have it in front of me. First of all, the CARES Act, when it ends, it won't matter about the 30-day notice part unless you're covered by the CARES Act, right? So it still has to be a building that has a federally based mortgage or whatever. But I guess what this question is asking is, um, would I still have to give a 30-day notice on July 25th or 26th, let's say past the deadline, if my lease has a 14-day eviction notice? Yeah, I think you'd still, if you're covered by the CARES Act, this is going to override that part of your lease that says you have a 14-day eviction notice for non-payment of rent. You'd have to give a 30-day eviction notice. A 14-day eviction notice for non-payment of rent, by the way, is pretty uncommon in Minnesota. I mean, it shows up in leases occasionally, and there's actually a specific statute that talks about it, but it's not the primary way that landlords tend to enforce non-payment cases because, in general, a landlord's giving a tenant an extra 14 days. In Minnesota, a landlord doesn't have to give a tenant any notice at all when they want to file an eviction for non-payment of rent or for any reason, frankly. The only time that a landlord does have to give a notice is because of the CARES Act, which has this 30-day requirement. So this federal rule stepping in requiring 30 days is an anomaly in Minnesota. The 14-day notice that it sounds like you have in your lease is not something required by state law. And in fact, you're giving up days by having that in your lease. I'm guessing this is a lease that somebody got online that's probably from another state. I give a landlord speech. I get a lot of landlord speeches, but some of them are quite lengthy. And one of the things I talk about is shopping for a lease. And the most important part of shopping for a lease from a landlord's perspective is it really has to be Minnesota specific. And you might think it is. It might say Minnesota at the top of it. But there's 5, maybe 7 leases that are used continuously by landlords in Minnesota. And you really want a Minnesota specific lease. If you don't have a Minnesota specific lease, chances are you're forfeiting rights as a landlord. And so I'd recommend, by the way, the State Bar Association lease, Minnesota State Bar Association lease, which is free to get. And you can find it online. And it's the one that I would use if I were a landlord, which I've told probably, I don't know, as many landlords as I've spoken to, however many groups that is, 200 groups of landlords. I almost always mention that if we're spending any amount of time together.
One other addition to this that sometimes doesn't come through in the Q&A is that, I mean, it's possible that since this person who's asking the question says the CARES Act applies, that this is public housing, which does have a 14-day.
Oh, I see what you're saying. Yeah, you're right. The details get lost in these questions, which are typed efficiently by folks. And again, we certainly appreciate people sending in your questions, and we try to answer whatever we can each time we get them.
So I got kind of a lengthy question via email. I'm going to try to cut down to
okay.
the important details. This is a landlord who owns a duplex and resides in one unit, and then the other unit is the renter. The renter appears to have been working during the entire pandemic. Submitted notes with the last 2 months of rent, and the note was a non-renewal at the end of the lease, which is July 31. Tenant has been approved to buy a home.
So I'm sorry, the tenant gave notice or the landlord gave notice?
It appears that the tenant gave notice.
Okay.
So that's okay. And then, however, the June rent check came back both late and with an NSF occurrence, and then again came back again with an NSF later in June when it said that the account was closed. The landlord's lease says there's an 8% late fee and a $30 NSF charge. They're in the lease and agreed to. Landlord was told by the Attorney General's office that late fees and NSF. I'm not sure where the question is, but I think maybe that's what the question is it okay to charge the late fee and the NSF fee?
Okay. First of all, the late fee that was mentioned is 8%. That is the statutory cap on late fees in Minnesota. So that gets past sort of our first check mark, is this late fee legal question. It's 8%, so that's okay. The NSF charge, also there's a statutory cap. You won't find that in landlord tenant law. It's not in the Minnesota the 504B chapter. It is, yeah, 'cause I can't remember the statute number, but it's a state law as well. But it's not just landlords and tenants. That's why it's not found in 504B. But it caps NSF charges at $30. So both of those are the ceiling, but they are the allowable ceiling. So those numbers are okay. Is it legal for a landlord to charge those right now? Okay, that's a different question. The CARES Act would be the first place I would look. Does the CARES Act play a role here? Does the landlord own a property that is Fannie Mae or Freddie Mac insured? And if so, then late fees are not allowed. I don't recall in reading the CARES Act whether the NSF charge would be allowed or not, which I don't know. I don't know the answer to that one. At the state level, there is no prohibition against late fees. So if the CARES Act isn't in play, then a landlord can charge late fees and an NSF charge. There's nothing stopping that from happening. Again, a landlord can't file an eviction right now, so there's sort of a limit, but can they say, hey, you owe me this? Under the rule, yeah, a landlord can do that in Minnesota. I know that we've mentioned this a couple of times over past sessions. A group called the Minnesota Multi-Housing Association. It's a landlord industry group. They submitted a series of recommendations before the governor actually even issued the eviction moratorium, one of which was no eviction should be filed until Memorial Day or the end of May. And the other was that I remember right now off the top of my head is that late fees should be eliminated, that tenants shouldn't have to pay late fees because they're losing their jobs, that sort of thing. But that was not included in the governor's eviction moratorium anywhere. So a landlord in Minnesota is still allowed to collect late fees during the COVID-19 peacetime emergency declaration, as long as the CARES Act is not involved in their situation.
Right. I think that was all the questions I see right now. And I was actually trying to find the section.
Oh, you're looking for the
I think
NSF charge?
Yeah. Well, I was first trying to find just the eviction non-sufficient funds, right?
Yeah, I can't remember the
I don't
name
know.
of it. You'll have to trust me that it's $30, and I could find it. I think I want to say 243 off the top of my head, but
Okay.
section
Well,
243. But it's not that important.
yeah, I'm not sure about the CARES Act, but I'll put in the chat. I think the Congress's website is hard to navigate sometimes, but the link to the CARES Act eviction section, which does explicitly say
No late fees. Yeah.
no late fees. Section 40-24. I don't know. Maybe this will work.
Okay.
Uh,
And yeah.
Go ahead.
And again, wanted to restate what we're going to be talking about next week. We'll be talking about our normal thing, any new changes that might come up between now and then. And people that have watched this, we've got some people that have tuned in every week. And we're happy that you're interested in what we have to say. And obviously you want to know what the latest is. And we're happy to share that with you. But you've noticed that new things pop up. And there's not a lot of warning sometimes. So you never know what might occur between now and next Thursday. But we're planning to talk about our best guess as to the number of evictions that will be filed roughly when the courts reopen. Again, we've done some analysis. We're trying to be as precise as we can. It will be an educated guess, but it'll be something that we'll be talking about for a few minutes next week, along with taking your questions.
All right. Well, with that, we'll end just a minute early here. And thanks all for joining. You will get an email follow up with the link to the registration for next week, as well as recording of today's video webinar. Thank you.